All right, we're going live in 3, 2, 1.
Well, good afternoon, everyone. Thanks for joining us. We're going to give it just a few more moments while everyone else lines in. One thing, Ellie, could you call the judges' chambers and let him know he's signed in? I believe maybe on the attendees link instead of on the panelist link.
Yes, I'm on that.
Okay, perfect. Thank you. Welcome, everyone. Everyone's signing in right now. And while we do that, let me just talk to you about some future upcoming events we have. The 2024 annual awards are Thursday, August 15th, 2024, this year, in Traverse City at the Del Mar Hotel. And we'll be presenting awards to Judge Ali Maldonado from the Michigan Court of Appeals, our Judicial Excellence Award. Our Distinguished Mediator Award will go to Todd Millar. And Lawrence Acker will be receiving the Outstanding Achievement Award. Also, we'll be receiving the MAJ and MDTC Respected Advocate Award, and Jenna Wright-Grieman from Kitch and Ron Weiner from Lipton Law will be receiving those awards, both incredibly well-deserved. And finally, we have a seminar on October 1st. It's going to be at the MSU Conference Center in Troy. And will be a live event with lunch and a reception that follows. We've got a great lineup of speakers. We have a national speaker, Michael Leeserman, the Zen lawyer, coming in to talk to us about practicing mindfulness and lawyer wellness. We'll have a number of speakers talking about jury trial skills and advocacy skills, including Randy Yipe and David Knotts, two wonderful lawyers, excellent trial lawyers. We've got a judicial panel that includes Judge Anthony Patty from the federal court, Judge David Groner, Judy Suskin is on that panel. So there's a really good program that day, so please sign up for that. And today we'll be presenting a seminar on Voir Dire, or Voir Dire, depending on where you are, which both the Negligence Law Section and ABOTA Michigan chapter considers voir dire to be an essential part of the right to jury trial. And we're not alone in that, because the Michigan Supreme Court in the seminal case of People versus Tybersky said that the right to voir dire, the right to have an exposition of potential biases, to make sure that a jury panel is well vetted, is part of fundamental due process. And it's that an abuse of discretion for a trial court not to allow appropriate voir dire. And we've got some experts in the subject to talk to you today. And with that, I will turn the reins over to Council Member Bryan Waldman.
Hey everyone, I'm Bryan Waldman. Can we get the next slide up there? Thanks. Before I do anything, I just want to thank our sponsors, Arcadia Settlement Groups, Jacobs and Deemer, Riley and Hurley, Ringler and Associates, and then my favorite law firm, the Sinas Dramis law firm. I'm an attorney at that law firm, and as Chad said, a member of the Negligence Section. On our next slide, we've got short list of our speakers tonight or today. Debra Freid from Freid, Gallagher, Taylor and Associates in Saginaw. Deb's also of counsel at our firm. She's the current vice president of ABOTA, past president of Michigan Association of Justice, a member of the American College of Trial Lawyers, and a fantastic trial lawyer from the plaintiff's side of the V. From the defense side of the V, we also have a fantastic lawyer, Tony Taweel of Smith, Haughey, Rice, and Roegge, with many offices, but he's located in Ann Arbor. Tony is also a member of ABOTA and was listed as one of the go-to lawyers by Michigan Lawyers Weekly in the area of medical malpractice law. And then our final speaker is Judge Jeffery Mattis from Oakland County Circuit Court. Before Judge Mattis became a circuit court judge in 2015, he was in private practice for 21 years and last at the law firm, I believe, of Guerin Luco, so has experience litigating negligence cases. and is going to provide us with his insights from the bench. So with that, let's start. Let me just say in the Q&A box, I will try to keep an eye on if people are typing questions. I'll do my best to keep an eye on the questions as the panelists are speaking, and I'll be able to see those questions and convey them either during the presentation or at the end as best as I can. So anyone watching, don't hesitate to type your questions in the Q&A box. I'm going to pull it up right now on my screen so that I can hopefully see questions as they're coming in. All right, so what I'd first like to do is, you know, like anything with the law, you don't just show up and get lucky. You have to prepare. And so what I'd like to first do is just ask Deb and Tony, you know, what is it that you do to prepare before trial specific to Voir Dire? What is that you're doing as that date approaches?
Or if I could start that. I just want to say good morning to over there, good afternoon. So the very first thing I do anytime is reread the court rule that applies. I take a look at some case law to refresh my record.
So I should let everybody know Deb is in an airport out west. And so her reception might be a little broken up, Deb, and I'll interrupt you if that happens. So can you try, what court rules were you telling us you were reading?
Oh, the court rules 2.511, 2.510, the court rules that deal with jury selection, essentially, and impaneling a jury. I'm a big fan of rereading court rules or evidence rules, should they apply, before I start a trial, every time. It doesn't matter how many trials I also always obtain the juror questionnaires from the court. That varies, as you probably know, from court to court. In other words, the access they provide, when they provide it, what they provide. So I always check with the court early enough to be able to actually view and study the juror questionnaires. And then I do a web search, among other things. Once I do a summary of those juror questionnaires, and I do a web search.
So
What about you, Tony?
Yeah, no, I was going to say my practice is pretty similar. I do reread. It's an absolute must to go through and reread the rules of evidence. I don't get into the jury, the MCR 2.511 and 510, other than to remember or remind myself how many preemptory challenges I have. But I do get the questionnaires, and if I have enough time ahead of time, I will go through and do a web search on everybody and sort of see what I can find and what I can't find. I have a list of standard questions for Voir Dire that I like to use, that I've sort of tailored throughout the years. And then I'll go through, and I generally put my Voir Dire questions together at the end of my prep. It's probably the last thing I do, because I want to get the theme down. I want to get my theory of the case down, my cross exams and direct exam sort of outlines put together, and that helps me to sort of tailor my questions to the potential jurors. And I think so. I'll start to then take my general list of questions, plug it into a table, and then get some specific questions relative to the case that I really want to hone in on, and then I start to refine it from there.
Judge Mattis, are there things you wish lawyers were doing to prepare that you see that they're not doing to prepare when they show up to pick a jury in your courtroom?
From time to time, unfortunately, yes, that does happen. Don't get me wrong, there's a lot of good lawyers in Oakland County and throughout the state that come before me that have clearly done their homework and have prepared and are ready to go. So, but yes, from time to time, there are issues. I would say, certainly the two big issues, I guess, in general that I would mention is the scope of the questioning and the length of the questioning. And again, we're talking in the context of where the lawyers are involved in the process. As we all know, under the rule, We talk about 2.511. There's essentially three different situations. One, the judge does it all. Two, the attorneys do it all. Three, it's a hybrid. The judge and then the attorneys follow up, and that's the way I do it. Is number three. I ask a lot of questions myself, bring out a lot of information, and then I turn it over to the lawyers. And I think one, that the scope of the exam typically from time to time becomes an issue. I personally believe there are instances where it is appropriate to discuss specifics of the case during voir dire, but oftentimes it starts to turn into an opening statement or closing argument, and there's an objection raised by that, and I think there is a line there. Just as by way of an example, let's say if someone said, members of the jury pool, you're going to hear testimony from expert witnesses in this case. You will hear an instruction that experts are to be treated like other witnesses, that if you are free to believe or not believe anything an expert says. Are there any of you who just will automatically believe an expert witness no matter what he or she says and not be able to follow the instruction? I think that would be an appropriate question. But sometimes attorneys start to tread into, okay, you're going to hear, defendant ran the light, hit my client and this and that, and next thing you know, it's opening statement. And I think typically that's probably where the line gets crossed. And then the other is the length of time. Certainly, I generally give some latitude to attorneys to ask questions, but at some point, you have to move the proceeding along. And certainly there are judges who are much more aggressive, I think, at shutting down questioning if it takes too long. And too long is sort of a general issue. There's no bright line rule, obviously, but I would say be focused. In your questioning, be prepared, cut to the chase. Certainly, if there are important questions you think you want to ask those first. So if you do get shut down by the judge, you haven't left the important questions unasked. So, those would be some general thoughts with regard to scope and timing that I've seen.
That's great. So as lawyers, I know that we all want to be able to ask the questions. The new rule provides that there have to be follow-up questions, or the amendment to the rule says that there have to be follow-up questions either directly from the lawyer or the lawyer submitting the questions to the judge, and then the judge submitting those follow-ups. Has anyone had any experience with just the mechanics of doing it that way?
I have not had a trial since last year, but, and the new rule, of course, just came in. But I think, and I'd like to hear what Judge Mattis thinks about this, but my sense is when a court is already concerned about time invested in voir dire, that the attorneys can make a strong argument that allowing the attorneys to actually do the questioning instead of submitting the questions to the court and then the court reviewing them and then issuing them, that you actually reduce the time, which is a concern often for judges, simply by allowing counsel to do those direct questions. So that's, the subpart, the first subpart, not the second. So that would be my thought on it. And Bryan, I wondered if we could just maybe revisit a little bit more of the trial prep or the juror prep, if I could mention one other thing that I thought was important. So, when you're learning about what the judge's perception is on how he or she wants voir dire conducted, if there is a difference, if as Judge Mattis mentioned, some judges are a bit more what I would characterize as strict, perhaps, in limiting time. And I think that voir dire is critical. So I've often prepared a brief for the court on the importance of voir dire, the reason to permit voir dire. There's all kinds of literature out there about that, and I think that's very helpful to the court, frankly. And in the last case I had, it actually moved the court from telling me I had 20 minutes in voir dire to allowing me to do the voir dire that was, in my view, necessary and much longer than 20 minutes. So it was very helpful.
Yeah. Yeah, Tony, you've expressed to me a concern about time limits. So what do you do to resist time limits, or what do you do if there are time limits imposed?
That's the hard part. It's hard to sort of assert yourself in front of the judge while you're picking the jury, because you don't want to come off as that guy. And so it's difficult. I often try to take it up with the judge before or during or after on a break, if possible, to try to get more time, because, as the lawyers in the case, we've lived with the case for, in most cases, in my case, 3 years. And so we've had this case for 3 years. We know every fact, every detail, every record, and what's important and what isn't important. Then to have a judge just say, okay, you got 15 minutes or 30 minutes to ask your questions and be done with it. It's a lot more difficult than that. There's a lot more that goes into it. And I don't think you can really pick or weed out, I should say, jurors with bias in that amount of time.
Yeah. And so, if let's say the judge sticks to the guns, to his or her guns, and you've got 30 minutes and you're trying a complicated medical malpractice case or an employment case or trucking case, whatever it is, are there certain things that, like to use the judge's words, cut to the chase, that you think you should be cutting to the chase on? And also, I think, probably respecting what Judge Mattis said about, there is something to be said about length. I mean, you don't want to disrespect the panel and ask everybody the same questions over and over and over, or make them feel that way.
No, yeah, that's the fine line. I agree. But yeah, no, if I have to cut to the chase, I get to any biases that they have toward doctors or hospitals. I think that's really where I start to hone in on, to see if anyone, the hospital's a corporation, can you treat it the same as you can an individual? And, do you put doctors up on a pedestal, or do you think doctors are just in it for the money, kind of a thing? I mean, I really try to focus in on that. And nurses, that's generally where I go. I go also to damages a little bit if I'm pressed for time. And I talk about the experts and the care that the doctor, my client's doctor, provided, and how, if we prove, or that I'm going to prove to you, that he didn't or she didn't do anything wrong, can you turn the plaintiff away without awarding any damages? And the whole sympathy factor. Those are the highlights for me, if I had to hit them.
So if I was pressed for time, and I will say that is a real problem in my mind. But if I was pressed for time, I would still start by trying to destigmatize bias. So what I mean by that is, most jurors and anybody wants to believe truly that they are fair individuals, that they can be fair, and that if given an opportunity, they will be fair. And courts can try to rehabilitate jurors by saying things like, well, if you understood the law and you hear the law and I tell you to follow the law, you will do that and you can be fair in doing it. And if you haven't provided an opportunity or an understanding to that juror that they can actually say, no, I can't do it in this case, and they will in fact, fail to stand up. So I always start by what I call destigmatizing the bias. And I do that largely by telling a story about a kind of case that I couldn't sit on. So, no matter how many minutes that takes, it usually takes me 2 or 3, maybe 4. I tell a story about a kind of case, not a specific case, but a kind of case that I could not sit on without coming to that case with a bias, an opinion, a feeling.
So you're
And
recognizing your own bias to make them feel more comfortable sharing whatever biases they may have.
exactly. And I say bias is human. I don't always use the term bias. Sometimes I do, but opinions, beliefs, feelings, biases, those are human. And what we want here is a juror who feels that this is the right case for them. In some cases aren't right. So I start with that no matter how little time I have. And then from there, if I really was limited as a plaintiff, I would absolutely discuss further proof, because often people, they're very in tune with criminal cases on TV, and they've heard beyond a reasonable doubt 1,000 times. And we do not have to bear that kind of burden. So I articulate that and I try to explain what that means in words, I use the actual juror instruction, more likely than not. I explain that more likely than not is 50.1% or 51%. And then I talk about, some people are uncomfortable with that. Some people feel really and truly we need to bear our burden more, to 60%, 70%, and we talk a little about that. Which way on what side would you fall? Would you be willing to accept that or not? And then I talk always about general lawsuit bias, usually before burden of proof. Do you just feel like, really and truly people come to the courts and they shouldn't? And lastly, if I was timed out, I would talk about damages. I agree with Tony 100%. Largely, non-economics are more important for a plaintiff to discuss immediately, and the sense of just verdict size, if it's that kind of case. So those would be the areas I would cover.
Right, and I think we'll probably come back to kind of more specifics on how to cover those areas, but I feel like we should come back to one of the points Judge Mattis made, which is arguing the case. I mean, typically, we often hear the reason judges put limits on voir dire, whether it's preventing the lawyers from asking questions or limiting our time, is judges get frustrated with lawyers arguing their case during voir dire or presenting the case during voir dire. I'd like to know from all of you, Judge Mattis, what you've seen, Deb and Tony, your experience trying. Is that an effective thing to do? I mean, lawyers are trying to do it, obviously, or judges wouldn't be saying they see it. Do you think it's effective when lawyers do that, Judge?
Well, I think, I guess in general, if there's an objection and it's sustained and they're shut down, it's probably not effective from the standpoint they didn't get to do what they wanted to do and ask questions. So I guess, it certainly depends how it plays out. And at least what I've seen, generally the other side objects whether it's plaintiff or defense, gets up and essentially is starting to give an opening statement or even sometimes a closing argument to the jury. And so, obviously having an objection made and the judge rule against you probably is not the best way to start the trial right in the very beginning when you're picking the jury. So again, I would say tread carefully when you get into the scope, of what you're saying, understanding like the example I gave, I personally don't see, I think it's certainly appropriate in some cases to reference some specifics of a case, if done properly. So in and of itself, just referencing the case to me is not objectionable. It's what you're saying. But just to touch on a couple of things, I think it's very important, obviously, for attorneys to know how a judge handles all this, before you show up the morning of trial. And I'm pretty candid with lawyers when I see a case is going to trial and it's a final pre-trial or getting near the end. I'll tell them how I do it so they know. And then to touch on, I think, a question you did ask that I didn't answer. You asked it after I spoke, but I've had a few instances when I did not permit the parties to ask questions, but I did allow them to submit written questions. Only a handful, and they were all self-represented individuals, criminal, I think one civil, but a few criminal, where there were very unique circumstances and concerns raised. And so in light of that, I let them submit questions. I made a record. I went through the questions ahead of time that I was going to ask. The ones I didn't, I explained why I felt they were inappropriate. And then I believe even during the questioning, if they had questions to follow up, I gave them that opportunity to write out questions to follow up on things being said. So, but that's only a handful of times. But in general, I ask the questions to start, and I really go into I ask a lot of questions, and I really try to get a lot of information out. I feel that I cover a lot of ground that the lawyers would want covered. And then, so now, I'm sure there's always a few things that I miss that they, ask fresh, but in general, what I see is the lawyers are following up on the answers that have been given during my questioning, where things come out, then I leave it to the lawyers to follow up on it. So I have a very lengthy sort of script that I've developed over years of lots of questions that I ask to get a lot of information, and then I turn it to the lawyers to follow up at that point, and obviously ask questions that they wish to ask as well. But so that's just generally the way I do it, and what I've seen in that regard.
Well, I mean, Tony and Deb, you agree follow-up is the most important type of questions that a lawyer can ask to get meaningful information?
Well, I think first of all, we have to recognize, I'm sorry.
Tony started to talk. I should do a better job of calling on one person. I'm sorry.
Oh, Deb, go ahead.
I wanted to kind of mention that we should note that Judge Mattis is really a special trial judge. And I can say that because I tried a case in front of him, so I know. So Judge Mattis does, in fact, ask a wide variety of questions, and you are following up typically. But often there are times when, that isn't the case. And so you are really laying some groundwork with your own questions. I think your question though, Bryan, about trying the case and the judge is concerned about it. I don't think it's at all wise to try your case in voir dire. It's in fact unwise. I think it impairs your credibility. You have not built any credibility with that jury. By then they have, you simply walked into the courtroom. So if you're going to try to persuade them before they've seen anything at all in voir dire, I think you lose credibility by doing that. And it's totally unnecessary. It doesn't teach you anything about the jury either, because your job is not to persuade them in voir dire. Your job is to learn about them in voir dire in order to be able to select, you hope, the best panel. So I think of issues when I'm doing voir dire. Just like Tony said, what issues are most important in the case? And that's how I approach voir dire. I am in full agreement that trying the case in voir dire is necessary.
Tony, do you see people trying the case? Do you make efforts to try your case, or do you agree with that?
No, I agree with Deb, but I'm an advocate, so it's very difficult for me to sit on my hands from time to time, and I will discuss the case and the facts, and these are, this is the procedure you're going to hear about, and this is why the procedure is done. Does anyone have an issue with that? I try not to argue the case, I really do, but it's hard not to, because I want to educate, and it's a fine line I'm sort of walking on. How I sort of I don't want to say get around, but how I've sort of do it in terms of arguing the case is, there are certain themes that sort of I interject throughout my whole case in my defense, and they center around reasonableness and fairness. And so I ask a lot of questions about fairness and reasonableness, and would this be reasonable, and would this be fair? And I'll give some examples that are kind of tied to the case and kind of not tied to the case, but to get them thinking about reasonableness, fairness, and the doctor's situation at that time with the information he had available to him or her. And then that sort of plants the seed for me to then, during the trial, put some water on those seeds so that in closing arguments, I can reap the benefits of the roses that I've planted and watered throughout trial.
Judge, we've got a question for you here.
Yeah.
When you do your kind of extensive questioning before you open it up to the judges for follow-up, we've got a question. Do you discuss the issues of bias or damages in your questioning?
Damages, I don't think so. I don't think I really go into damage issues. I will say that I'm going to read you instructions throughout the course of this case. And one of the things I'll say is if I read an instruction that you personally don't like, that you don't agree with, you understand your role as a juror is to follow the instructions and the law that I read to you, whether you agree with it or not, in terms of following the instructions and the law. Is there anyone who believes that you could not do that? It's not specific to damages, but in general, making sure that they have an ability to follow the law and the instructions. So with regard to that, with regard to bias, absolutely. You know, I will ask, I'll ask a variation, a variety of questions that could touch on that. For example, let's say it's a medical malpractice case. I'll say, has any of you, frequently I'll say, you, significant other, family member, or close friend that impacted you, have you ever had an experience with any doctor or medical professional that was extremely favorable or extremely unfavorable, that in any way impacts how you look at medical professionals? Invariably, someone will raise their hand, yes, you know, and then something will come out. Now that starts potentially down the road of bias. And then I'll usually at some point follow up in light of what you've just told us. Do you believe you'd have any bias for or against either side? And some people say, yes, I would be biased. Others, no, I can be fair. But then, of course, then lawyers can certainly follow up on that. So that's something that, you know, typically comes up. I had someone once explain, what does bias mean? And I said, well, let me give you a sort of non-legal, but maybe a way to understand this. I said, you think about it, like we were all in high school, and let's say you're out on the track and you're going to run a 100-yard dash, and you got two people running a race, and they both start at the same spot to start the race, right? And they both have to run the same distance. Now, you know, obviously burden of proof and the plaintiff, you know, slightly get into that. But the point is, if one starts 50 yards ahead of the other before the race even starts, before you've even heard any evidence, before you've done anything in this case, and you're already giving one an advantage over the other side for any reason, that's a bias, that they're both not, you know, starting at the same spot, you know, equally in terms of you have an open mind, you haven't heard anything, you're starting fresh. And then, of course, I do always explain, you understand, as was touched on, this is not a criminal case. You've probably seen shows on TV or movies where we hear beyond a reasonable doubt. This is not what we have here. It's a civil case. Plaintiff has the burden by a preponderance of the evidence, simply more than 50%. That is the burden that the plaintiff has. So I make sure they understand that. But in terms of trying to give them an idea of, you know, what a bias is, that, you know, it's an unfair advantage to one side over the other before we've even begun the proceeding.
Well, speaking of biases, what about lawyer biases? What about conducting voir dire or making decisions not based on facts, but based on our own kind of preconceived beliefs about people because of their education or some general stereotype that we may have? Any thoughts about
Really
that?
a bad call. Bad call. Every time I've made an assumption, absent one, I've, you know, found out that I shouldn't have done that, fortunately through questioning. In fact, if I tell a war story, is that going to be okay?
Yeah, sure.
Sure.
Okay. I tried the case in
long
fact,
as
we
it's
tried
good.
in front of, well, okay. I'm not great at telling war stories. I'll do the best I can. The case I tried in front of Judge Mattis, in fact, on the panel before, you know, during selection, there was an individual who, as I recall, was a dispensary owner and operator. And for some reason, my immediate gut reaction was that type of individual is likely to be more, I'm going to use the kind of classic term, more liberal. And as it turns out, in questioning the panel, including this individual, about whether or not they could enter a verdict that included substantial non-economic damages, the response from this individual was something along the lines of, never in the world, it would be, it's the destruction of our society. And I thought to myself, obviously I was completely wrong about the person. Having said that, sometimes engineers do require data.
Yeah, right.
So,
Well, but
I
that
try
reveals,
to avoid.
right, that reveals a certain bias, obviously, that this,
Yeah.
that this potential
Right.
jury.
It just wasn't the bias I expected.
Sure. Brian, if I could
Yeah.
jump in on one other thing, there's also certain areas or certain things I personally feel it really is my job to vet with the jury pool, and probably easier for me to address. One is sort of the length of trial and any, conflicts of schedule or, availability that jurors have. Ultimately, I think that buck really should stop with the judge on that. That's how I feel. So I go into that. And the way I always handle that, and obviously that's a difficult subject because, from a judge's standpoint, if you start letting people go easily, others are seeing that. Next thing you know, you've opened the floodgate. Everybody wants to be gone. So there's a balance, I feel. So what I always say is I usually hold up a piece of paper and I'll say, I'm sure when everybody got this jury notice and summons to be here today, the first thing you didn't say was, all right, I'm going to court to be on jury duty. And usually it draws a little bit of a laugh from everybody. And I say, I understand it. You have jobs, family commitments, responsibilities that had to take a back seat for you to be here today and throughout our trial if you're served. And I'm sorry that happened. And I tell them that. But one, I'm a trial judge and I can't do my job if you're not here. So I need you to do my job. And then the second thing I say is I want to impress the importance of our process and our system. And I say, even today, in places in the world, there are places where people are literally grabbed from the streets. They're taken away, taken from their homes. They're never seen again. And they don't have the rights that we do. They don't, in a criminal context, they don't have the right to be represented by an attorney. They're not presumed innocent. They don't have the right to have a jury hear the case, that the people have the burden of proving their case beyond a reasonable doubt. Or even in a civil context, people who claim they've been injured through the negligence of other people don't have the right to bring a case and have people hear that case. And it's important. And we do have these rights. And this is a system we have. And the system can't function without you. And it is public service. It's like voting and other important things. So it is important. I appreciate you being here. And to the extent that you can set aside other obligations, and of course it depends on the length of the trial. If it's a few days, that's much different than if it's a month. But for a few days or whatever it is to serve on our jury, I would greatly appreciate it. And I make that statement. And then I say, now, if anyone has, if you're leaving tomorrow morning for Europe on a trip that you booked a year ago and you've paid a ton of money, you'll never get back, and there's a bunch of other people going with you that are all going to have hardship because of you having to be here, I want to know about it. So essentially what I'm looking for is a unique, unavoidable, and severe hardship with you having to be here. And I phrase it that way. And then I say, is there anything we need to talk about? And sometimes I've gotten nobody. People will just say, we're good, Judge, in light of what I said. Other times people will raise a hand and then they'll raise an issue. And, obviously they're different, different levels of, viability, if you will. Example, I remember I had one trial once where I had a woman who was a single mother, lived in Pontiac. She worked in a restaurant. She was paid per hour. She had like 3 kids. She said she had no savings. She lived check to check in an apartment. And if she had to, it was a lengthy trial. It was like a 3-week trial. If she had to be here, she couldn't make her rent. They'd be thrown on the street. I mean, that to me is like the height of, if anybody situation justifies excusing somebody, to me, that's about it. Obviously other situations where someone says, well, I have a job and, I get a salary, so I'm not going to lose any money, but I got a lot of work to do at work, and being here for a few days will back me up. You know, that's a different situation. But that's an issue I always address, because at the end of the day, I feel that I can present it in a way. One, it needs to be addressed, because certainly if somebody truly has a legitimate conflict with time and they can't serve, we need to know about it. And two, I feel that that's really my job, and I can address it in a way to bring the discussion out rather than the lawyers. You know, but we certainly discuss it, and I usually typically ask the lawyers to approach the bench so we can evaluate these situations when someone raises it.
Okay, so you've raised a lot of issues there that I want to kind of circle back on. One of them, the length of time of the trial relates to the number of jurors that may be that we may set for any particular case.
Yep.
And then once you decide how many are going to set, you've got the issue of how many are going to decide. Obviously, the court rules say 5 or 6. The lawyers can agree differently. Tony, do you have any general thoughts on how many you'd like to see in a case, and what issues will help you decide whether you keep alternates, don't keep alternates? How many should there be making the final decision if you do keep the alternates?
Yeah, I like 7 out of 8 usually. If I can get some extra, and then I always decide on the alternates depending on how the evidence goes in. So, you know, sometimes that's a tough question to answer up front, I think.
Yeah, I mean, obviously, well, Deb, what do you think from a plaintiff's perspective? I guess it's a little different than 7 out of 8, but maybe not. I mean, I suppose the true defense perspective is 8 out of 8, but what do you think?
Right. I tend to follow the protocol, what's necessary. Although I'm not opposed typically to allowing alternates. So
Yeah.
that kind of.
So
the general.
I was just going to say, my procedure is if the lawyers work that out, obviously the number you pick extra depends on how long it is. You know, I had a month-long med mal case once. I had another case was 1 day. Obviously, that's going to be different, you know, in terms of how many you pick. And certainly when we were trying cases during COVID, we picked a lot extra just because things could happen, you know, certainly, and we could lose people. But so that depends. But my procedure is if the lawyers agree, you know, to keep them all, and however many is a verdict, as long as the lawyers all agree, I'm fine with it. I'll do what the lawyers agree to. If they can't, and every now and then that happens where they can't agree, then I just follow the rule. And I will say that it is my standard practice after the case is over to go in and thank the jurors for their service. And I do bring, if there are alternates that are excused, I typically do retain the alternates for a period of time, certainly, and depending on the circumstances. If the alternates are there, certainly I'll bring them in and thank them as part of, you know, thanking the deliberating juror. And I have had a few instances where alternates were not happy about that situation. I sat through this whole trial and then I got excused and I didn't even get to deliberate. I was here for a week or two. And so I think people certainly appreciate being included in the deliberations if they've invested the time of being there. But obviously, it's ultimately up to the attorneys. If the attorneys agree, I follow that. If not, then I follow the court rule.
So one of the other things that was mentioned in what you try to establish when you were trying to set the tone that people are not going to be excused easy is one of the things that we typically hear. I think you said opens the floodgates. We've heard like poison the panel. There's probably more artful. Taint the jury pool. And so we see, you know, one of our common complaints as lawyers is kind of efforts to rehabilitate someone who clearly has a bias. Is there anything? Well, Deb, do you have any general thoughts on that or suggestions on how to kind of prevent that from happening?
Yes. So I tried very, very, very hard to prevent a rehab. And the way you do that, I think, is by establishing, again, that first concept that it's okay to have an opinion. It's okay to have what we're calling a bias. And I need to find out about them. And then we talk about, we'll ask a question, whatever that question is, and whatever it is we're trying to find out. And then, you know, once someone expresses a belief, then I hone in on that belief. So if you're asking them about the burden of proof and, you know, which person are you closer to, somebody who needs more likely than not, etc. Once you get an opinion that you believe it demonstrates a bias, or in Tony's case, you know, they're more favorable to doctors. Once you get that opinion, then you focus on the opinion. You talk with them about how long have you held that opinion? Have you had circumstances in your life that, you know, generated that opinion? Do you hold that opinion firmly? Have you discussed that sort of thing with family, with friends? You know, and then you go on to the idea that no matter what I were to do, given that, would you agree that you would be carrying that opinion with you as you make these decisions, that you'd be carrying that opinion in so that you couldn't really weigh these issues without being burdened by the opinion, Ellen? And I would go on a few more times until they agree that essentially, although they would want to, and despite trying their best to do so, they would be unable to assess the issue, whatever that is in the case, without being affected by or burdened by that particular opinion. And once you do that, and usually a juror will go with you on that. Once you tell them it's okay that they have their own opinions, they will do that. And I've routinely defeated rehab. And I think often, you know, most good judges like Judge Mattis, they do not routinely try to rehab people. When they hear a cause challenge that has merit to it, I mean, you know, judges want the cases to be tried by fair jurors. So, but there are times when you do get that immediate effort to rehab, and if you've built up that juror and honed in on the bias and given them that question, so in the end, no matter how much you tried, no matter how much you wanted to, you would be burdened by that opinion, by that bias, and coming in, you can often defeat a rehab.
Tony, do you have any general advice for kind of questioning that leads to showing a bias or setting up a challenge for cause?
No,
any experience?
I was going to say, I think Deb hit the nail right on the head, where, you know, if you can show that the bias comes from some personal experience, I think that really is where I focus in on those type of questions. You know, if the person's mother had a bad experience at the hospital I represent in that particular trial, and he just, every time he walks into the place, he has PTSD. That, I think, is where it lies. I think it's a little bit more difficult to really establish that type of bias if it's just someone who just in general thinks that all doctors are horrible. You know, because I'll just sit there and spin my wheels arguing with somebody like that, and I don't tend to think it gets anywhere. I think if there's a personal experience that the potential juror expresses, 9 times out of 10, the lawyers will get together and sort of agree that, you know, I'm not even going to try to rehabilitate him. Let's just talk to the judge and see if we can get this guy out.
Yeah.
So
Yeah.
typically it's the lawyer trying to expose a bias, showing what they think is a bias, and then moving for excusing the juror for cause. But Judge, do you ever have any instances where a lawyer tries to excuse someone for cause who's shown a bias toward their side as opposed to against their side or in favor of the other side?
Yes, I have. I've had that happen before. Again, I try criminal cases as well as civil. I'm sure it's happened in a civil context, but I can remember some instances in a criminal context where a juror made statements that, you know, there was a police officer going to testify. So there were questions about that. If an officer comes in, you understand there's a jury instruction says you're to treat that officer like any other witness. You don't give them more credibility just because they're an officer. You don't give them less. Treat them like anyone else. Can you follow that? I can remember a few people either went both ways on that. No, police always lie. or the other way saying, oh yeah, if an officer comes in, he or she has to be telling the truth, and I would absolutely believe them no matter what they say. And the prosecutor sought to excuse that person, clearly recognized, and obviously it was a position favorable to the prosecution, but just said, Judge, there's clearly cause here and bias, so I'll ask that he be excused, even though he helps, his side. So yes, I have seen that. That's not that common. Obviously, it typically more goes the other way, where the attorney making the request for cause is because the bias is against, his or her client. And I would say too that, from a judge's standpoint, again, sometimes it's obvious. Someone expresses cause or except bias, there's cause clearly, and either an attempt at rehabilitation fails or there's no attempt, and the record's very clear, there's bias, cause granted. More often than not, however, it's not always that clear. There is an attempt to rehabilitate, and it becomes more muddled. Well, I know what you said, but really, after you hear the evidence and couldn't you really be fair? And well, yeah, I think I can try. Yeah. And then it becomes and then of course, then the lawyer opposes the cause saying, well, wait a minute, but yeah, I know he said he was biased, but then when I asked questions, he kind of said, so I view mine as, I look at the totality of the record, not just one comment that rehabilitated. Yeah, he kind of backed off. And I agree with what Tony said. If it's tied to specific things, it's a case. Let's say even in a civil contest, let's say it's an auto neg case where there was an alcohol. The defendant was intoxicated, caused an accident. It comes out that a juror's brother was killed by a drunk driver. And then the strong feelings that comes out. That to me, tying it to a specific event or something that the person referenced and in their initial statement for bias, even if they kind of later say, well, I can do this and that, I'll grant the cause. And then I would make a very quick, short record and just a few statements about why I'm doing that. But yeah, I've seen that.
I just wonder if that's an effective way to gain credibility, take one of your medical malpractice cases, Tony. If you had a potential juror who said, I think all doctors go into medicine because they want to help people. If they make a mistake, I could never hold it against them. And they are going to stick to their guns and never, ever. I mean, you figure the other side's going to challenge that person anyways. Why wouldn't you just do it? And have the credibility to say, hey, I'm looking for fair people, not my people.
Now that particular juror, I wouldn't challenge, but if it were like I've had this happen before where it's a nurse who's in the jury, and I'm thinking, this case is about physicians. Nurses generally tend to, there's a little bit of animosity between the two, and I ended up excusing a nurse. And I remember hearing one of the jurors behind me sort of whisper oh, he got rid of the nurse. He didn't want that nurse knowing what happened. So something must have gone bad because she knows the medicine. And ever since then, I don't care what kind of medical profession is on that jury, I won't excuse them. I figure they're either going to side with me or not, but I'm not going to take that chance of looking like I'm trying to stack the jury one way or the other.
Yeah. Have you asked for people to be dismissed you thought were kind of showing a bias in your favor, Deb?
I have. I mean, I remember one in particular. It was very clear. They said that they would. They said we're much more on your side, etc. And I asked that juror be excused for cause. I said I appreciate that, but when it was time, I asked the juror to be excused for cause. And my feeling is aligned with what your question was, which is that if you stand in front of that jury and you start your voir dire by talking about how important it is to get a fair, unbiased panel, and then you allow without challenge someone who says in front of everybody else, I'm going to find for the plaintiff, then if I don't bring that out cause, I think that does affect my credibility. And I think that when I've had that happen at least once recently. And I think by challenging that individual cause, everybody on that jury understood that I actually did want an equitable. I would do it every time.
We as lawyers, at least I have no idea what you're taught at judge school or judicial conferences. Is there ever a concern raised in the education of a judge that by trying too hard to rehabilitate someone who clearly has shown a bias or an inability to be fair, that it compromises the integrity of the system? Or, you know, as we're sitting here telling the jurors we're trying to pick a fair panel, that we're trying to do things to seat someone who clearly has shown that they probably won't be fair.
You're talking about rehabilitation efforts by attorneys or by the judge?
No, by judges. I mean, is there, you know, when you know, is there ever a concern in the educational process that if you put, you know, is it ever taught that if you push too hard, you're hurting the integrity of the system? Because we're telling these people we're trying to find a fair juror, and then we see someone who seems like they're not fair by all accounts, and then occasionally we have these mammoth efforts to rehabilitate them.
Yeah, I don't know that I can say specifically that was addressed at any judicial seminars I've gone to, you know, while I've been a judge. I mean, it may have been, but you know, again, I can address, you know, what I do, and I personally don't, I really don't try to rehabilitate people, I guess is the way I say it. I might ask, I try to ask very neutral questions. I don't steer things in any direction. When I'm asking jurors questions, I might follow up, and the rules certainly allow you to, you know, if it's a little unclear to me, I might follow up with some questions that are more neutral about, you know, I mean, do you think you can be fair or not? Do you think you have a bias or not? Something like that, just to try to flush out further discussion. If there was a rehabilitation effort by a lawyer, and now it's a little bit unclear in my mind, I might want that juror to just speak a little bit more on the subject to ultimately help me to make a ruling. But, you know, I can tell you that as a lawyer, I tried a case once where essentially the judge just asked the jury, well, can you all be fair? Yeah, okay. All right, well, we're ready to go, you know, and very little questioning, and that's good enough for me, you know. And, you know, obviously I recognize there should be something more than that. But yeah, there's no doubt. I mean, some judges want to move it along, and I'm sure they do, you know.
And if it really comes down to that little inquiry, I mean, you're asking the lawyers to rely completely on their biases and prejudices to just, you know, stereotype people and decide who you want to keep on based on no information. So we've talked about challenges. What about peremptories? What challenges for cause we've talked about? Those are unlimited. Peremptories, the court rule says 3 aside.
Yep.
And remind me, Tony, it's 3 aside, but each side, well, it's 3 per party.
3 per party.
But
unless your interests are different. Otherwise, it's each party gets 3, but if your interests are the same, then the defendants collectively would get the 3.
All right. So are there things you strategically do to try to change your numbers?
Yeah, I have a united defense throughout the entire course of discovery, and then right before trial, everybody starts to fight. No, you know, that's difficult. That's difficult subject to broach, because the defendants have to make that decision on how the trial is going to go forward. And I sometimes don't talk with defense counsel about their trial strategy purposely. So most times our interests are aligned if we're on the same side, particularly if it's a hospital who's vicarious for a doctor. There's really nothing I can do there. Rarely do the defendants point the finger at each other. So we generally, if I have 3 people sitting there, we all have 3, and we all generally tend to collectively agree on who we're going to, you know, exercise one of the peremptories each time it goes around.
Yeah, and certainly, let me just jump in. There's a lot of strategy, certainly, in terms of exercising peremptories. And then, of course, the other issues, do you use your third preemptory or not? And that's something I've seen come up. Some lawyers believe, no, I don't want to be in that position. Others say no problem, and they use them all. I will tell you, I had a trial once where an attorney used all three, excused somebody, and then the next person seated was a lot worse than the person in their view that they had just gotten rid of. And then they tried to establish cause, which I did not, and clearly did not exist in my mind. So now you imagine that you've used all your preemptories. You now essentially mount an attack against this juror, make it cause, try to excuse him or her. Judge denies it. Now you're stuck with this person who knew you wanted them off. And you don't have any more preemptories. So that's always, you just got to be careful how you handle that, because once you've used them all, then all you have is cause left. And if you don't have cause, you have no way to get rid of them.
Right, and obviously the risk of using your last one is that you're stuck with whoever replaces them, but the risk of not using your last one is if you're going to challenge how the panel, that you're going to challenge the whole panel, or you're going to challenge any place where the judge didn't go along with your request for a challenge for cause. As a general rule, you've got to use up all your peremptories, right?
Absolutely.
Yeah. So there's a lot of considerations there, and obviously a lot of strategy calls that an attorney has to make.
What about just general advice? How you're going to get the best information for you to consider to do your job? How you question, the types of questions you ask, whether you ask questions of the group as a whole, or you go to individuals, whether you ask leading or open-ended questions. Deb?
Okay, so I really think you have to get the juror questionnaires. You must do a summary of those questionnaires, and you must do, at minimum, a web search, not only of the individual, but you can easily find spouses, partners. You can do a white pages search. I mean, it matters in the end. So then you know a little bit about the individuals as they're coming up. And then I think that I talk to each juror. The judge has already done the broad-based questioning. So you've already made the notes from what the judge has asked. And then so you are following up on that, and you're hitting the issues that, for example, that Tony's talked about, the issues that are in your case. If mine is a discrimination case, I'm talking about discrimination. I'm talking about disability, if that's what it is. I'm talking about my client, just in general. But then, as you're listening to the answers, you start making judgment calls, not only about the individual, but about how you can see them relating or not relating, right, to others. And I always ask open-ended questions. I mean, your whole point in Voir Dire is to ask them to talk with you, right? The more they are talking in Voir Dire, the more you are learning. If you're talking the entire time, you're learning nothing at all. So I ask open-ended questions and I talk with them. And at the end, people who power through that panel, those are the people you better be very careful about. Those are the people who you have to make sure. In other words,
I'm not sure I follow that. People who power through the panel.
Well, I remember in the last case that I had, there was an individual who, a lot of times when juries start or jurors are being questioned, they are very quiet, right? It's an unusual situation. They're not comfortable. They don't particularly want to be there initially. So they're quiet. But in this particular person's case, there was no sense of being quiet. He wanted to control the room. He wanted to control the group. And so that's what I mean. And so that's the kind of person that if I were looking at a last preempt, for example, if I was in that situation and I couldn't get that person off the cause, that's a person I would preempt out. So that's what I asked.
So we've got a question that says, just curious, if there's an attorney that appears for jury duty, do you usually excuse them? And I think that's a good question for Judge Mattis, but before you answer that, Judge Mattis, Tony, you've actually been on a jury, right?
I have, yeah. I got called Frank Murphy on a criminal case, and they put me in the box and asked me what I did. I said I was a defense lawyer, and I think the defense lawyer thought, oh, he's a defense lawyer, he'll be good for us. And the plaintiff lawyer, or the prosecution, I think, understood like I was a civil defense lawyer and thought I'd be conservative. So I'd vote for them. And all of a sudden I sat on a criminal jury for 2 weeks.
Is there
which was-
something you learned from being on kind of the other side of
Oh
the-
yeah, yeah. You know what? The one thing I did learn is they watch everything going on in that courtroom, because you have, 10 people sitting there and everybody's looking at something different. So you go back into the jury room and all of a sudden it's like, hey, did you see how the mom reacted to that line of questioning? And I'm like, no, I'm listening to the question. I'm looking at the witness. And, she was looking at the mom, and then someone else would come in and say, did you see the way the defendant shuffled in his chair during that line of questioning? I'm like, no, I was looking at the witness. So it was very interesting because you got to see everything that went on in that courtroom, even though you weren't looking at it. So that'd be a lesson to you. Keep your clients steady and still during the whole thing.
Judge Mattis, any opinions about kind of what Tony said, or about the question about how you feel about lawyers being on juries in general?
Yeah, so no, I don't excuse an attorney. I don't think the rule in and of itself says an attorney should not be on a jury. I've had jurors who were attorneys. I can tell you some of my colleagues on the bench have served as jurors, some judges that I know. I never have. I didn't get to that far along in the process, but so invariably though, through the questioning, things come out that I usually see result in the person being excused by one side or the other. If someone, is an attorney that works, in the insurance defense field for a big insurance defense firm, typically the plaintiff's attorney wants the person gone. If they're, a prosecuting attorney, if they're a criminal defense attorney, and generally through the questioning, one side or the other does not want the person on the jury. What I've seen, but it was more their practice and what they do, and sort of a belief of how they're going to come down on issues, as opposed to just that they're a lawyer. So I would say, yeah, an attorney certainly can serve. I've had attorneys serve, and I think it just depends on the situation, really.
Brian, I was going to say, I actually left a lawyer on one of my jurors. He was a patent lawyer, so I figured he was very technical. It was a medical case, malpractice case, and it had some technical causation issues. So I figured, you know what, I'm going to leave him. And the plaintiff didn't kick him off. And it was a no cause. We got a no cause, but I did talk with him afterward, and he loved the experience.
Yeah. So,
Right.
yeah.
Can I just pick up on something that Tony had said?
Sure.
Tony said that when he was sitting on the jury, he was seeing that jurors look at everything. And I think that is a really important learning piece for lawyers trying cases, because that is absolutely true. They look at everything you do. They look at how you appear. They look at how you treat your client. They look at how you interact with other counsel and the court.
Mm-hmm.
They, if you walk in and I never try a case unless I am just like the juror. And what I mean by that is, if they can't have water, I don't have water. If, I never pull out a phone ever once. I tried a case where, believe it or not, where counsel on the other side routinely had his or her phone out throughout the court, throughout the trial. And at the end, when we talked to the jurors, that was immediate what they said. Why was that lawyer watching phone? And then, they said, well, we tried to give that person the benefit of the doubt, that maybe, they were looking at the case, but somehow on the phone. But they said, we really didn't believe that.
And they're not just watching you in the courtroom. They're watching you when you come through the metal detectors. They're watching you in the parking lot, potentially.
Yep. Absolutely. Absolutely. You know, I always thank the jurors after, and I talk to them a little bit, and I hear a lot of comments. I will say one time I had a trial where one of the two sides was extremely aggressive, was objecting to almost everything, the entire trial. And one of the jurors said, well, I figured, you know, he must have had a bad case. He didn't want us to see the evidence because he was just constantly hiding the evidence from us by objecting so much. And of course, I sustained a lot of his objections, but the jury, it was so predominant throughout the whole trial that it impressed the jury reacted to it. So that's a point I always say, you know, just because you can object doesn't mean you always should. And you have to be aware the jury's seeing everything, and what you do and say can have an impact.
We want jurors to be observant. We want jurors to listen. What about comments about lawyers listening? You know, to me, you know, you can ask the best questions you want during voir dire, but if you're not listening to the answers, how are you going to do your job? Do you see, you know, do you have an opinion on note taking? Judge, do you have a comment just in general about lawyers conducting voir dire?
I think you can't be you can't be a robot in terms of, if you have a script, right? You've got to be able to listen to the answers. I have had instances where I've asked a question and something came out that if I was a lawyer, I sure would have followed up on, and it wasn't followed up on. And I can only assume they didn't hear it. They weren't paying attention. But yeah, you've got to listen to the answers, look at the juror and what's their body language? How are they reacting to, you know, when the questions are being asked? You know, do they sit like this, you know, or, you know, is there something that's coming across by what they're saying or how they're acting that should be followed up on? And certainly I allow lawyers to do that, but yeah, you've got to listen. You can't just be going through your script without paying attention to what else is happening, what's being said.
How important is the body language to you, Tony? I mean, when you're questioning jurors and you're concerned maybe that they're telling you what you want to hear, does body language play into your decisions about who you may decide you want to use one of your peremptories on?
It to a certain extent it does. I mean, but I think I'm pretty decent at reading people and body language. So, you know, it is part of the overall picture that I look at, but I think more important is what the potential juror says. I mean, I agree with Deb, who said, you know, ask open-ended questions. You want the jury talking, you want to talk the least amount possible. And I think that's how, you know, we as the lawyers start building a rapport with the jury. I mean, you know, I see lawyers stand up and they say, you know, can you be fair? And can you know, take your bias out? And they just ask 10 leading questions and sit down. And it's like, man, that was pretty ineffective. And then when you get up and start asking these open-ended questions and ask why, you know, if you could say, can you be fair? And then say, but why? Tell me why you can be fair. And then they start talking and engaging. I think that's where the real magic happens, in terms of you being able to listen to what they say, look at how they're reacting, sort of seeing some of the other jury or jurors. Are they shuffling in their chair? Are they nodding in agreement? I mean, that's where it really all comes together for me. So it does play a little bit of a role, the body language, but it's more what the person says.
Deb, what do you
Bryan?
think? Yeah, nonverbal communication.
I think, well, what I think is that it's very difficult for lawyers to do voir dire by themselves. I mean,
Oh, that was going to be
done
my
it.
next question. Yeah.
Oh, I'm sorry. Well, then.
No, that's
Okay, well,
fine.
then
That's great. Let's do it.
Okay. So let me just mention one thing, and then we'll go back to the not by themselves. But, you know, when Tony was talking about asking the open-ended questions and getting people talking, one of the ways that I do that is by giving them an alternative. You know, so for example, you know, some people feel that nobody should file a lawsuit because blah, blah, blah. And some people feel that it's perfectly right to file a lawsuit if blah, 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 right? Whatever you're talking about. Which way, you know, which belief are you closer to? And then you give them an option, so they kind of have to answer. And then you get them talking. And once you get them talking, they do that. what I was going to say about doing voir dire alone is, and I've done this many, many times alone, and I find it extremely difficult because you cannot watch everything. You know, you can't be thinking about every question. You can't be listening to every response. You can't be watching every juror. And sometimes it's just as important to watch the jurors who you are not questioning at the moment, right? To see what and how they are reacting to the question and the answer being given by the one you are questioning. So if it's at all possible, you know, I like to have somebody with me at least, but and somebody you've explained, you know, if they aren't another lawyer, you've explained what you're looking for and why you want them there. But I do think it's challenging to do voir dire solo.
So Chad or someone, I don't know if we're gonna open this up to verbal question and answer at some point, or because we've got about 15 minutes left, I think. Or if because we did the chat Q&A, if we want to just keep rolling.
I would say just keep on rolling. I will just, as I've been sitting here watching as an audience member, so to speak, it's been a fantastic conversation. I know Judge Mattis is actually in the middle of a jury trial, and so he may need to check out. So what I wanted to do, if we could, is just give Judge Mattis a few minutes to give some overall last thoughts and some pointers for effective voir dire before he has to go and adjudicate and preside over a jury trial.
You know, I guess to highlight a few points. So certainly, I guess from a lawyer's perspective, you know, I would want to know, you know, well before the morning of trial, how the judge does it. You know, the idea that I'm just going to show up that morning and find this all out, you know, as the pool is coming in the room is really not the way I would do it. You know, I think you need to find out ahead of time. Obviously, if the judge is going to conduct the voir dire, certainly, as we know, you know, the rule, the amendment, you know, we've touched on, says that the court must permit the attorneys for the parties to, one, ask further questions that the court considers proper. So you do have that in there, or submit further questions the court may ask if it considers them proper. So at a minimum, if the judge is going to do the voir dire, only the judge should let the parties submit questions. So, you know, when do those need to be submitted? And, you know, certainly put some thought into the questions that are going to be asked. But you want to know that ahead of time. And certainly the preparation that's been referenced by, you know, the other panelists, I think, you know, spending some time thinking about it and all that, I think that's appropriate. And then just really pay attention. I agree, you know, in terms of, it is a lot. I tried a lot of cases as a lawyer. I tried some myself, some with others. And it is helpful if you have somebody there who can, you know, tip you off to things you might have missed in terms of, you know, things you've seen or heard. And then certainly if the judge does allow you to ask questions, as I do, you know, just follow up on things that were said that should be followed up on. Ask questions that weren't asked that you think are appropriate. Certainly, if you start treading into the details of a case, be ready for an objection and explain why you think it's an appropriate question to ask during voir dire, as opposed to, you know, opening statement kind of thing. And then certainly just, you know, be aware of the law on what is a cause. I know there's, you know, that's specifically laid out in the court rule, and, you know, every now and then I'll get an objection on cause that really is not cause, you know, and, you know, I think it's important to know that. And there's some that, you know, perhaps people don't always realize. Example, one of the questions I ask is, have you ever been a juror before? And then people, you know, yes, no. Some say yes. Okay, how many times? What was it? What was the case about? One of the reasons that I do that is because the court rule, I think it's 2511E6, says that that can be a basis for cause if you've been on a trial of the same issue. And so it raises up. Now, in a criminal context, that comes up more often, that somebody was on the exact same charge as our case. In a civil case, you know, maybe it's a little different, but you could potentially get somebody who was on a med mal trial before, and now it's a med mal case again. And then all of a sudden that's an issue. So certainly be aware of what the law is on what is a cause. If it's not, certainly then, you know, you have your peremptories. Be aware of that issue. Do you use them all or not? certainly for an appellate issue, you got to use them all. But in the same respect, you know, if you use them all, now you've got your worst nightmare just got sat down. You know, I always say, you know, whether it's the defense getting hit on a big verdict or the plaintiff getting a no cause and going up on appeal, that's generally not the situation you want to be in, even if you think you might have an appellate issue. So just lots of strategy, think it through ahead of time. It's common that when that's all occurring, lawyers are talking to their client who's sitting there. And of course, certainly perhaps may depend on who your client is, how involved they are or want to be. But I have no problem. Sometimes lawyers will say, Judge, can I have a minute to talk to my client? Sure, no problem. I'll give you a minute, talk to the client, but certainly discussing that ahead of time with your client. Okay, here's what's going to happen. We're going to pick the jury, you know, blah, blah, blah. And at some point, I'm going to ask you, you be watching the jurors. Tell me what you think. And then certainly that helps cover the lawyer too, in terms of if the client specifically wants somebody excused and you do or don't. If the client tells you, yeah, I'm happy with the jury, you know, presumably the lawyer can memorialize that in some way. So down the road, if the client, you know, some adverse result occurs and they say, wait a minute, you should have kicked that person off. Wait a minute, you know, I talked to you about it. You were okay with it. At the time, we thought it was appropriate. So, I mean, just a lot of strategy. Think it through. Be prepared for different scenarios, and certainly, you know, follow the law, represent your client, and know the judge. Know the judge and what the judge does and doesn't allow as best you can.
Right. Thanks, Judge. We're gonna continue on if you need to get to your trial.
Yep, I do. I need to get back to my med mal trial. So I just want to thank everybody. Thanks for inviting me. I appreciate it. Thank you to my panelists and your comments and just everybody out there. Good luck to everybody.
Thanks for participating, Judge.
Thank you. Have a good day.
For the rest of your time. Yeah. Deb and Tony, we've got a question that Judge Mattis kind of hit on a little bit, but it's from an experienced lawyer, Larry Acker, wanted to know what type of participation you afford your client in your peremptory challenges. And you know, I suppose it depends on the case. What factors would you look at?
I generally, I've never had a client. I mean, they give me like this one and don't like that one, but they've never said, I want number 4 gone type of a thing. I think they leave that decision making up to me and co-counsel most times. I've never had that happen.
I always ask my client what their thoughts are, but I've never had anybody tell me that they wouldn't keep or should, or that I should.
Yeah, and I'll just add in particular, because Deb's freezing up here, that I ask my clients, but I'm very conscientious of what Tony mentioned before, the way that jurors interpret what's happening. So I would hate for a juror, you know, I would hate for my client to point at juror number 5 and say, I don't like that guy's shirt, or, you know, I don't trust that person, or I don't like what they had to say about whatever. So I always give my client a pad of paper. I tell them that if you're going to communicate with me, you do it through notes. Doesn't mean I won't whisper with them a little bit, but I also give them a little debriefing on keeping a poker face and being conscientious that they're being observed at all times by someone. And so they really need to be careful about that. What about local counsel? Anyone ever work with local counsel and get input from local counsel in the jury selection process?
There's times I wish I would have.
No, yeah, Barry or Brian, I've never worked with local counsel. Most of my docs are local here.
All right. Well, I think you've both been very, very helpful. If anyone has anything else to add, kind of some last minute parting advice, now's the time to do it. You can tell Deb's already kind of making her way to wherever she needs to be next.
And as well, you'll be getting a survey.
I'm
All
so
the
sorry.
attendees will be getting a survey. Oh, I'm sorry, Deb, I interrupted you.
Any additional final advice from Deb or Tony? Deb, you go first since your connection is supposed to be a little bit weaker.
I would just say, you know, listen to the judge, look at the judge, and respect the judge. You know,
It's tough to hear, but I know I've heard this from Deb before, the importance of establishing credibility by showing the jury you respect them by making eye contact and listening to their answers. What about you, Tony? Any last minute advice?
You know, I was going to say just having a conversation with them,
Yeah.
and, you know, connecting with them. To me, that's the most important. That's what I try to do, while at the same time, not necessarily argue my case, but discuss the facts of the case and some of the strong points and some of the weak points of the case while helping or while selecting them.
All right. Thanks for joining us, both of you, and have a safe trip, Deb.
Thank
Yeah,
you.
be
And,
safe.
well, you'll be getting a survey. And if there's additional ideas or issues or topics you'd like covered in future CLE opportunities from the State Bar of Michigan Negligence Law section, please do let us know. Bryan, thank you for an excellent job moderating this very interesting discussion to our panelists. Everyone have a great day, and Deb, safe travels.
Thank you,
Thanks,
Chairman.
everyone.
Thank you.
And there was a question. This was recorded, and it'll be posted to the State Bar Negligence Law section website in our archives for anyone that missed it or wants to refresh their memory with anything.
Great. Thanks, everyone.
Great. Thank you.
Bye.